scenes. I am your host, Hector Montalvo. This show is dedicated to asking tough questions for you, the viewers. We bring you their responses, and we let you decide. Joining us here today at our MCTV studio is no other than my favorite attorney, Mr. Dick Consoli. Also joining us, his law partner, Krista Wilshusen, and from our Rhode Island Bureau, Mr. Brian Hutchings. Welcome to the show.
Thank you.
Thank you.
Today, I want to talk to you guys about a couple of different issues. And why don't we start with the recent ruling of the SJC that came down that basically says that judges should not be required to disclose what they were thinking at the time of their ruling. And this has to do with ethic investigations and so on. What is your take on that?
Well, I think that the court is trying to draw what is a difficult line in terms of wanting to obtain from the judge the rationale or justification for the decision. But it's very difficult to get into a judge's head in order to determine whether a judge is basing a decision on prejudice or bias. I think that from both the court's point of view, but also in terms of lawyers, one of the things that lawyers routinely will do is to scope out the particular judge that they're going to be appearing before in order to determine what their preferences are, what their foibles are, and whatever. Like the rest of the human race, they're human, and they have preferences and things that they dislike. It would seem to me, rather than trying to get into the judge's head, that the more effective way of determining whether a judge is being prejudicial is to effectively monitor the decisions that that judge has made in order to determine, is there a pattern? Is there effectively indication that there's a prevalence on the part of the judge to be opposed to the state's position, the district attorney's position, to have a preference and to be more supportive of defendants or certain parties in a case. I think that's the only way you're really going to be able to get at it, because otherwise it's a very, very difficult way to try to analyze. And on the other hand, judges ought to have the freedom to be able to make decisions, hopefully objectively, based on what the law requires. And that decision, if reviewed by people competent to review, you would assume that they would come to the same result.
And also, if someone didn't like the decision that a particular judge did, they do have options, correct? I mean, they can actually appeal it from their decision up to a higher court?
Up to a higher court,
That's right.
So they can actually do that. But the regular average Joe has to answer for what they do. I mean, you would have to answer.
Absolutely.
I mean, you would have to, and Mr. Hutchings would have to answer. We all would have to answer because they demand that.
Oh, and I think that under the perfect system, judges ought to be subject to scrutiny. You talk about supervision. There ought to be some monitoring that goes on that doesn't necessarily require an attorney to bring suit or to take it up on appeal. That for a variety of reasons, both in terms of the decisions that they make, but also in terms of how well they handle administratively decisions so that they generate decisions on a timely basis, there ought to be some supervision. And beyond that, there ought to be some additional training. It would seem to me that, like the rest of the human race, and with the law evolving as it does, that somebody that's been sitting on the bench for the last 20 or 25 years might need some brushing up to bring them up to speed, and also in terms of social developments that have occurred over the last several years, so that you get someone who is a 60 or 65-year-old judge ought to probably get some updating in terms of what is currently happening socially within the community and within the society, because many times they're called upon to make decisions where they don't have sufficient insight into what is really going on out there, and as a consequence of that, may not necessarily make a decision that is appropriate for the particular circumstances.
And I know being a judge is probably a difficult thing. I mean, you have to have knowledge of the whole entire system, the whole entire law system.
That's right. But also have to keep up, so that what you learned, when you first brought to the bench, say 20, 25 years ago, the law and society are not static. They're dynamic. They're constantly in a process of evolving and expanding and the like. Judges have to keep up with that, because otherwise, if the mindset that they have is the same mindset that they had in 1960 when they get appointed to the bench, it's one thing to be antiquated and obsolete when that person is sitting on the bench and making significant decisions that are going to have a profound impact on the people, the litigants.
Well, we know that most laws that apply to the regular person doesn't apply to elected officials, legislators, and in this case, with the SJC ruling, people can take that to say that judges are above the law, that they're not required to answer to anyone, and that's the type of indication that this type of ruling basically gives. Now, if we can't hold judges accountable because they won't talk to the media or they won't talk in response to that, should the Commonwealth of Massachusetts consider maybe electing judges in the state of Massachusetts? That way, there is some type of accountability on behalf of the people. What do you say about that?
No, I would agree with you. I think it's definitely an accountability issue. And judges, as you know, are appointed for life here in Massachusetts. So, and they're supposed to remain objective. But as Attorney Consoli's pointed out, if you've got a judge that's sitting on the same bench for 20, 25 years doing the same work over and over, how does that judge remain objective and not have a bias and not have a prejudice? So the idea of having them have continuing education to make sure that that isn't happening, and maybe rotating the judges now and again, so that they're experiencing different courtrooms in different types of cases, so that they're not becoming jaded. Because the worst thing is to have, especially where this ruling, I agree with you, I think the ruling doesn't hold judges accountable. And they're appointed for life. They don't need to be, it seems, to be accountable. But if they are elected officials, then certainly that would be they would have to be accountable, because then they would have to be accountable to their constituents.
And I believe there is a department, a state agency that's responsible to receive complaints from judges, and you can correct me if I'm wrong. I mean, these particular organizations do not even disclose that a complaint was actually filed against a judge. They don't disclose the investigation or the outcome of the investigation. So again, there is no accountability
Well,
whatsoever.
I think they need to be held to account. I'm not so certain that there necessarily has to be disclosure, as long as there's remedy where they effectively get back on track again, because my concern would be to undermine people's confidence in judges. As to the issue of election, my fear in electing judges is that the same, because that we would be inflicted with the same problem we have with elected officials generally, is that, and God help us if we end up with a bunch of politicians sitting on the bench where they've got an eye on the next election, and their decisions are effectively not based on the facts as presented to them, but rather on the basis of how is it going to play with their constituents. This is one thing I'm certain of, and that is we don't need more politicians. We need, I think, an objective, well-trained judiciary that can provide and rely upon the law and be prepared to explain their position in reliance upon, with some substance to it, which in other words, based upon the law, and to monitor them, and as I say, it's been suggested to see that they continually, on an ongoing basis, get training in order to make them, continue to make them effective. Politicians, we met our quota a long time ago.
And I tell you, we talk about lawyers, we talk about politicians, but we have so many attorneys up there that are supposed to be qualified attorneys passing legislation. These attorneys are supposed to know the law, and as you can see by legislation, that there's always loopholes in these pieces of legislation. So,
Right.
God help us with the judges, but God help us also with the attorneys that are
Absolutely.
representing
And
the...
there's little or no excuse for it. I think the classic example of it is the fact that the larger number of people sitting in the legislature are themselves lawyers. They have less reason than most people, and have every reason to be familiar with what happens in the court system, despite the fact that they have got to recognize that the judicial system doesn't operate as effectively as it should, and that the court system itself is underfunded. They make little or no effort to make certain that, in fact, that the judicial system from which they came, gets the kind of attention that it ought to in terms of supervision, in terms of the appointments to administrative positions of people who are qualified, and that the funding of the system, the probate and family court is a classic example. They've cut down staffing. Up until recently, we were short 2 judges. It's been chaos. Getting a case heard on a timely basis, absolutely impossible.
But with the struggles between the legislation and the judiciary, which basically controls most of the money that goes into this place, people can take it as, the court is playing games with the legislators by, cutting down, reducing clerks, reducing judges, slowing down the track. So there's 2 different ways that you can actually look at that as well. So I know that there is a lot of reform that needs to happen within the whole entire legal system, and hopefully we'll get that. I want to talk about another interesting ruling that the SJC came down with, which basically says that children cannot be included into restraining orders. Now, we know that the Commonwealth of Massachusetts issues anywhere between 15 and 30,000 restraining orders a year. And now restraining orders, for those people that don't know and are watching at home, they are civil in nature. They're only criminal if it was violated, okay? So what I want to ask you is, a 209A on a civil order, okay, and I know that there are different kinds of restraining order. There is the harassment order, which again played a big part in this. There's children restraining orders, and there's the 209A abuse, which is for someone that's been in a relationship. Now, and I just want to say, anyone can go in and get an application for a restraining order, but they must meet some qualifications in order to get it. And one of those qualifications, a couple of them are, you or your abuser are or were married. That's one of the requirements to get one, okay? Or they reside together in the same household. Not necessarily married, but you can live together and have an ongoing relationship and be able to get one. Or if you're in a dating engagement and so on. By blood, marriage, or if you have a child in common or something like to that effect. And the courts can issue certain type of rulings. What are some of those rulings that the court can actually issue once someone files a restraining order and they do meet those qualifications?
Well, they can issue a no abuse and no contact order, which is a combination of, because you can issue a no contact order or a no abuse order or a no contact and no abuse order, which would mean that they would have to refrain from being in the presence of the plaintiff. It's usually 100 yards, sometimes it's more. It depends on the circumstances, but the judge could order that the defendant stay away from the home, the marital home or the home that they lived in, their place of work, a school. If their children are attending a school, they could be ordered to stay away from the school. And it's usually for a 10-day period. And then you have to return to court to see whether or not the 209A will be extended.
Now, it's a temporary order, but within those temporary orders, you mentioned that they order you to refrain from physical abuse or contact in some cases, to leave the house and so
Right.
on. All of this without due process, because in the beginning stage, it's all done ex parte, which means
Correct.
one person goes in and does that.
That's correct.
What are some of the effects that a restraining order can cause someone? Just having a restraining order issued on you, what are the long-time effects, if you know?
Well, the long-time effects is even if the restraining order is vacated or dismissed by the moving party, if they decide to go in or not show up after that 10-day period and it's dismissed, it's still on the person's record. So whether you're applying for employment, going to school, whatever the situation may be, and they have to do a background check, that's always going to come up because my understanding is the restraining order goes into the domestic violence registry database, and the only way for the individual to get that removed is to do a motion to expunge. And I know that we're going to get to that topic, and that's a difficult standard to meet in order to get the expungement of a restraining order. So it could have long-term effects on somebody.
Correct. So now we know that the restraining order for the first 10 days removes a party from their house, whether it's a male or a female. It will order you not, in most cases, not to have contact with the children. Now we know that the Family and Probate Court, which is a civil division of the judiciary system, is responsible for hearing cases involving children in their best interest. And we see that children are being added onto a restraining order. So basically, the restraining order has a long-time effect. As you mentioned, it does go into a registry database system, which is controlled by the Commission of Probation. Now, the problem is that it affects a lot of different professions. If you're a police officer,
Right.
now you're stripped from your gun because you can't carry a particular weapon because
Right.
of the restraining order. That's one of the laws that tells you, if there's a restraining order, you have to surrender all your weapons. So you lose if you're a police officer, you're in trouble. What do you do now? If you're a parent, you can't see your children. But we find that after the restraining orders are vacated in the court system, most people don't know that it does stay on a domestic violence records keeping system, okay, which is the registry data, and I think it's its 20-year anniversary this month, September. The problem is that the Commonwealth of Massachusetts seems to be opposing any type of expungements. And Brian, I want to bring you in because you've done a lot of extensive research in regards to the expungement process. Why don't you fill us in on what you've learned in regards to the expungement process and how people can actually get their restraining order removed from that registry?
So the law for the civil registry, that doesn't define the expungement process. So the commissioner's office is under the impression that it can't be done. But I did have the Brockton District Court expunge my restraining order. But then later on, the commissioner's office came along and filed motions to undo it. And they're using the statute for the civil registry. And then in the statute, it says they're supposed to maintain the issuances or the violation. And then the commissioner, when they enacted the civil registry 20 years ago, what they did is the general court had the commissioner of probation then define his own policies for the maintenance of the record keeping. And then they took that report and just incorporated it into the civil registry. So now, anytime and then there's a 2006 appellate case where a woman was trying to get her restraining order expunged. One of the reasons, two of the main reasons why she wanted to get it expunged is because it affects employment stuff and it affects her ability to be a parent. And then the commissioner's office came up, so that one, the commissioner's the court, that was the Springfield Court, District Court, and they actually denied the commissioner's motions. So the commissioner's office actually took that and appealed it. And now it's a civil matter, but now you have a state agency bringing actions against the plaintiff of that case.
So let me ask you this, because he brings up an interesting point. If it's two parties involved in a restraining order, normally a boyfriend, girlfriend, husband, or wife, and a judge vacates that particular order, by the probation department and the trial court's attorneys coming in to oppose expungement, is that an indication that the Commonwealth of Massachusetts is inserting themselves as an actual party to that particular case?
Well, no question that is in fact the case. The issue is that the present holding, as I understand it, is that the only time that they would expunge would be at the 10-day hearing and only on the basis of fraud, if that were clearly stated. There's no question that restraining orders are many times used as a device by one of the parties in a divorce or in a paternity or related matter to gain an advantage by falsely accusing the other party of abuse or intimidation or the like. It's difficult from a lawyer's point of view, as well as the court, because more often than not, whatever happened usually happens not in a public place, not in the presence of a third party, but between a husband and wife or between lovers, alone in the room. And so the issue really is being able or having to rely upon the credibility of the parties. But sometimes an innocent person accused of abuse may not be articulate, may not present well, whereas the accuser, is going to get the Academy Award for the best dramatic performance. So you really, sometimes, you can't even rely upon the perceived credibility of the parties in order to make the determination. And from a court's point of view, particularly in a circumstance where there are kids, the worry is that if I don't allow the restraining order and something happens over this weekend, next Monday morning, I'm going to be on the front page of the Boston Globe because I refused the restraining order, and as a consequence of that, somebody became a victim. So the inclination, the part of the court, is to err on the side of caution in order to avoid that happening. On the other hand, in a circumstance where it clearly has been demonstrated that there was a false accusation, there ought to be a means of expunging beyond the very limited amount of time and circumstance now. And there ought to be a penalty involved for the person who has falsely accused another. It ought not to be a situation where they simply walk away without any consequence or any penalty for what they've done. And sometimes they'll use it to gain advantage in terms of the kids. That in a circumstance where they want to prevent the non-custodial parent from having visitation because they don't want the father around because their boyfriend or doesn't want to be reminded, and they simply want to pretend that the father doesn't exist, but keep the child support payments coming.
Exactly.
And you end up in that kind of situation.
Right. And I just want to get really quick to some statistics that we found, and I just want to find out if these restraining orders have an effect with these numbers. And let me just let you know that the Bureau of Censors tells us that 63% of youth suicides are from fatherless homes. Okay, so again, if a restraining order was issued and the father was ordered to stay away, 63% of the youths suicidal. 90% of all homeless and runaway children are from fatherless homes. We have 85% of children that exhibit behavioral disorder from fatherless homes, okay? The Center for Disease Control says that 80% of rapists motivated by displaced anger comes from fatherless homes. That's a huge concern.
Absolutely.
71% of all high school dropout comes from fatherless homes. 85% of youth sitting in prison grew up in a fatherless home. So we know that restraining orders play a big part of this. And what it's saying is that these statistics translate to mean that children from fatherless homes are 5 times more likely to commit suicide, 32 times more likely to run away, 20 times more likely to have behavioral disorder, 14 times more likely to commit rape, 9 times more likely to drop out of high school, and 20 times more likely to end up in prison. These statistics show or give an indication that there is a problem with the system creating this type of issue based on restraining orders.
Absolutely.
Where should legislation be focused on to resolve these issues?
One of the problems that the statistics support is the fact that when there's an absent parent in a household, there are consequences. A little boy or little girl that wakes up and one morning and his or her daddy is no longer there, they don't blame the father and say, well, that no good son of a gun, who left. The absence of a parent leaves the child feeling as though they're unloved. If I were lovable, if my father loved me, he wouldn't have left me. And as a consequence of that, it diminishes their sense of self-worth. If my father can't love me, who can? And they carry that wound, that emotional wound, within them into adulthood, and it has a profound effect upon them as adults. Because of that diminished sense of self-worth, if my father can't love me, who can? They end up falling short in terms of accomplishments, in terms of schooling. They end up in relationships that they ought not to be involved in. And as you suggested, they accomplish less. It's all at a cost. And there ought to be more information available to remind people of what the consequences are, to be mindful of the cost that's associated with mothers and fathers, husbands and wives, not making an effort, a good faith effort, to avoid causing that harm to their children by, if not preserving a marriage and a relationship, at least taking the steps necessary to see that no harm is going to come to their children.
Well, let me tell you, this topic is not going to go away. I mean, we continue to watch these statistics go up, and we hope that legislation in the future will work to resolve these issues.
Hector, I'd like a copy of those statistics,
Yes.
because what I'd like to do is to distribute a copy of those statistics to every client that I see. I run a volunteer attorney program down at the probate court. Every person that comes in ought to get a copy in order to at least make them aware, maybe for the first time, of what the consequences are
I tell
to
you,
failed marriages and failed relationships.
that is correct. And
Hector, you're in the life-saving business.
we hope so. That's why we're a national award-winning show now.
With good reason.
Here is the copy
All
you
right.
requested, and I want to thank my guests for coming in to talk about this very important issues that affect a lot of professions out there.
Absolutely.
Thank you guys for coming in. Brian Hutchison from Rhode Island Bureau, thank you. Ladies and gentlemen, thank you at home for watching. You've been watching Behind the Scenes. Join us next time as we go behind the scenes to ask the tough questions, bring you their responses. We let you decide. Thank you for joining us.